Contract practice is a vast subject area and can seem overwhelming for candidates working towards their APC. It's impossible to fully understand the wide range of construction contracts in detail, and instead candidates should really try to focus on the specific forms of contract they have adopted on their own projects. From experience of helping colleagues pass their APC over the last 7 years, I compiled the following Q&A to provide some examples of the different kinds of questions you may receive on the contract practice competency. The following 50 questions and model answers are split into 3 key areas, with the first 20 questions covering general contract practice knowledge at Level 1. The next 15 questions are aimed to cover examples of Level 2 and Level 3 questions based on the JCT suite of contracts. The first question we'll take a look at asks what elements must be in place in order for a contract to be formed. And candidates can first of all make reference to capacity. At the very least, this means that people signing the agreement must be of sound mind and must be fit and well to understand the responsibilities of the proposed agreement. Candidates can also make reference to intent, and this means that there is a clear intention for both parties to do business together. The most secure way to prove intention is to put the contract in writing, and this commits the agreement to paper form, allowing a record to be kept of the terms that have been approved. Candidates can also make reference to consideration, which is another crucial part of any contract, and this allows anyone reading the agreement to see what benefits each party will receive from taking part in it. In legal terms, a contract cannot be considered valid if no consideration exists, so something of value must be exchanged. The contract must also be lawful, and the obligations of those performing the contract must be legal for the contract to be enforceable. The parties would usually create and sign a contract based on the area where the proposed obligations are taking place, and this guarantees that the business being done is properly protected by the most suitable and local contract law. There must also be offer, where a contract needs to explain the nature of the offer and demonstrate what is being exchanged. This will set out what product or service is being provided, how and when it will be exchanged, the cost of the exchange, and who is responsible for what responsibilities within the transaction. It should also explain what will happen if somebody doesn't fulfill their obligations under the contract. There must also be acceptance, and this is where there is clear acceptance of the terms from the parties, which is usually shown by their signatures. And finally, there must also be clarity of terms. And this is where, to avoid a breach of contract for either party, the agreement must create certainty of its essential terms. This refers to the commitments listed on paper that are integral to the functioning of the contract. For example, the description of the services or goods being provided by each party, and the contract must clearly identify the key parties involved, as not doing so may lead to a lack of privity. Look, if you're finding this video useful so far and you're serious about passing your APC, we put together a question and answers revision guidebook, and this will save countless hours compiling revision notes and contains over 1,000 questions and answers based on real-life APC interviews. It also contains example submission documents and explains step-by-step how to complete the APC. Along with the step-by-step guide, there is also a free APC diary template, along with revision mind maps on the RICS hot topics to support your revision. The study guide has helped around 90% of my colleagues pass their APC first time, and I really hope you find this a useful resource when preparing for your APC. Grab it now using the link in the description below. And the next question we'll take a look at checks the candidate's understanding of the term time at large. And to address this, candidates can advise that time at large means that the main contractor has not fulfilled their obligation to meet practical completion. However, we must also state that following the non-completion, a certificate of non-completion has not been issued. This means that there is no set completion date, and it carries the implication that the main contractor only has the obligation to complete the works within a reasonable time. It also means that liquidated damages cannot be claimed, as there is no set date to apply them from, and the employer in this event would have to try to prove that the contractor had not completed within a reasonable time. The next question we'll address checks the candidate's understanding of the term frustration, and to address this, candidates would need to advise that frustration occurs when any event or circumstance beyond the control of both parties changes the contractual obligations or makes it impossible or illegal for them to fulfill their duties. The happening of such events automatically discharges the contract, and in the piece of case law Davies Contractors versus Fairham UDC, 3 basic points were established that must be met in order for frustration to have occurred. This requires that the frustrating event is not caused by the default of either party. It requires the contract to have become impossible to fulfill, as it becomes something entirely different from the original agreement, and it also requires that there is no provision within the contract covering the eventuality that is the frustrating event. The next question we'll take a look at is how is a contract under deed different from a contract underhand? And to address this, candidates can advise that a deed is signed by the parties as well as a witness and is traditionally authenticated by seal, whereas an underhand form of contract is only signed by the parties with no witnesses and no seal. The limitation period for an underhand contract is 6 years, where the limitation period for a deed contract is 12 years. The next question we'll take a look at is how would you respond if the client advised that the LADs were to be £100,000 per week. And in this scenario, candidates could advise that we would check the LAD figure is based on a genuine pre-estimate of financial loss and explain that in the event LADs are to be applied, they would need to be substantiated. I would also explain that if the figure inserted into the contract is shown to be punitive and not based on genuine financial loss, it is not likely to be enforceable. In this scenario, the employer will have to pursue the main contractor for any direct loss that can be substantiated through a formal dispute resolution procedure. The next question we'll take a look at checks our understanding of the term liquidated damages, and to address this, we would need to advise that liquidated damages are a genuine pre-estimate of the likely loss incurred by the employer should the completion date not be met. A follow-on question we may receive is what items must be in place in order for LADs to be deducted. And to address this, we would need to advise that a non-completion certificate must be issued, along with a payless notice and any other documentation or notices stipulated within the contract. We may also receive a question on what would happen if the employer actually suffered no loss or damage, and to address this, we would advise that in this event, regardless of whether the employer has suffered damages, is irrelevant, and the damages can still be deducted at the value stated within the contract. The next question we'll take a look at is checking our understanding of the term defects liability period, and to address this, candidates can advise that the DLP is a duration at the end of the contract, usually 52 weeks, after completion has been achieved, whereby the contractor undertakes any defects that arise within the structure at their own expense, providing they were due to materials and workmanship not being in accordance with the contract. In the event that the contractor failed to rectify defects, the employer may employ another contractor to carry out the remedy and recover the cost from the main contractor through the retention money that has been held. The next question we'll take a look at is if there is a discrepancy between the employer's requirements and contractor's proposals, which documentation prevails? And to address this, we would need to advise that the contractor's proposals take precedence in the order of hierarchy, as these sit above the employer's requirements. The next question we'll take a look at is what is a bespoke contract? And to address this, candidates can advise that bespoke contracts are where the contract conditions are drafted specifically for a particular project. We may receive a follow-on question asking our understanding of the advantages standard forms have over bespoke contracts, and to address this, candidates can advise that standard forms are written by legal experts where rights and obligations of each party are clearly set out to the required level of detail. The risks should have been allocated appropriately between the parties best placed to receive them, and parties should be familiar with the provisions in the form, providing greater consistency in application and fewer unforeseen anomalies. The time and expense of preparing a fresh document for each occasion is avoided, and case law is built up over time, which provides a good source of knowledge and clarity of the terms. We may receive a question asking our understanding of the disadvantages that standard forms carry when compared to bespoke forms. Candidates can advise that under standard forms, the apportionment of risk is rarely questioned and therefore becomes implicit, meaning it is not reviewed on whether it is appropriate. They may not be appropriate to the needs of a particular project or client, and using an inappropriate standard form for the project will cancel out any advantages. The next question we'll take a look at is when would you look to use a bespoke contract rather than a standard form? And bespoke forms are generally used for major projects with novel obligations, when specialist advisors can undertake the amendments, as this requires great skill and knowledge. The next question we'll take a look at checks the candidate's understanding of the term retention of title clause. And retention of title clause is where the subcontractor or supplier retains ownership of materials until they are paid for by the main contractor. This highlights the importance of vesting certificates, as the employer may subsequently pay for materials that are not owned by the contractor. And due to retention of title clause, if the main contractor has not issued payment, then the subcontractor will retain ownership of the materials. This legal principle can lead to disputes in the event of insolvency. The next question we'll take a look at is checking the candidate's understanding of the term collateral warranties. Candidates can advise that collateral warranties create contract relationships between the main parties of a contract with an external third party. The contractual relationship would not exist with the third party due to privity of contract. The next question we'll take a look at is what parties may require a collateral warranty. And to address this, we can advise that any third party with a financial investment within a project but not party to the main contract may require a collateral warranty. This could include funding institutions or future tenants and purchasers that may use collateral warranties. The employer may also want a collateral warranty with key subcontractors or suppliers, as if the main contractor were to go into insolvency, they would have no contractual link with them for redress in the case of defective workmanship. The next question we'll take a look at is testing our understanding of the term assignment, and to address this, candidates can advise that assignment is where the rights and benefits of one contractual party are transferred to a third party. A follow-on question we may receive asks what is the standard commercial position regarding assignment, and to address this we can say that it is standard to allow the assignment of rights twice without consent, and that assignment should be notified in writing to the other party under the original agreement. We may also receive a question asking how is novation different from assignment, and to address this we can say that novation is where a new contract transfers the rights and obligations of one contractual party to a new third party, whereas assignment is a transfer of contractual rights or contractual benefits only, as burdens cannot be assigned. We may receive a question asking what are the key issues after a design team has been novated. We could advise that one of the key issues is whether the new party has the right to take action against the novated party for breaches that occurred before the novation took place. The next question we'll take a look at tests the candidate's understanding of the term fitness for purpose. And to address this, the candidate can advise that fitness for purpose is a contractual obligation where the provision of the service being provided must be provided to the level where it's suitable for the employer's intended purpose. And this is a much more onerous obligation than reasonable skill and care. We'll now look at questions focused on the suite of JCT contracts, and the first question we'll take a look at is what does JCT stand for? And to address this, candidates will need to state the Joint Contracts Tribunal. We may receive a follow-on question asking our understanding of the main parts of JCT contracts, and to address this we can advise that these are the recitals, articles, contract particulars, attestation, and the conditions divided into 9 separate sections, and the schedules. We may receive a follow-on question testing our knowledge of the different types of JCT forms of contract available. To address this, we could make reference to the minor works form, the intermediate form, the standard building contract, also known as SBC, the major projects contract, and design and build. And we may receive a follow-on question asking us to name each of the 9 sections, and to address this, we can make reference to definition and interpretation, carrying out the works, control of the works, payment, variations, injury, damage and insurance, assignment, third party and collateral warranties, termination, and settlement of disputes. We may receive a question asking us to explain when we would look to use a JCT minor works form, and to address this we could say that this is where projects are of short duration on a small scope with a straightforward construction. The JCT guidance advises that these are normally used for a value up to £200,000, and they are normally used where the works are undertaken via a lump sum where design should be completed prior to execution. The employer or their team is to provide specifications, drawings and a schedule of works. We may also receive a question asking us to explain when we would look to use a JCT intermediate contract. And to address this, we could say that the intermediate form is recommended for projects that do not exceed 1 year in duration. The project should be of a simple nature, requiring only basic skills and trades, where services are not complex and where the works are already designed. The next question we'll take a look at is when would you use a JCT standard contract with quantities? And to address this, we could advise that a JCT standard building contract is used where the works have already been designed at execution. It is suitable for use with a bill of quantities. The next question we'll take a look at is testing the candidate's understanding of the relevant events within the JCT form. We would need to advise that the relevant events are events within the contract that entitle the contractor to an extension of time. Different relevant events are comprised of 13 events in total, and these include variations, instructions, execution of an approximate quantity, deferment of possession of the site, suspension by the contractor for non-payment, the carrying out of works by statutory authorities, impediment, prevention or default by the employer, also damage incurred through specified perils, exceptionally adverse weather conditions, strike or lockout, civil commotion or terrorism, and the exercise of a statutory power after the base date by the UK government. And we could also make reference to the force majeure relevant event. The next question we'll take a look at asks, can you have an extension of time without a loss and expense claim? An extension of time does not automatically mean entitlement to an L&E claim, and therefore you can have an EOT in isolation. When pricing an extension of time, what would you include for and what rates would you base this on? And to address this, we need to say that when pricing an extension of time, I would include costs for prolongation of site cabins, site utilities, welfare facilities, management, security, cleaners, and inefficient use of labour and plant resources, subcontractor mobilisation costs, head office, finance, and loss of profit. The next question we'll take a look at is testing the candidate's knowledge of the different certificates under JCT forms of contract, and to address this we could make reference to interim certificates, practical completion or sectional completion certificates, non-completion certificates, certificates of making good, and the final certificate. The next question we'll take a look at is what is the difference between partial possession and sectional completion, and to address this we need to say that sectional completion is a contractual obligation to hand over the section at the stated date, whereas partial possession relies on the contractor's consent. The next question we'll take a look at is, do the works have to be totally completed before practical completion or sectional completion is achieved? And to address this, we can say that practical completion is a vague concept. It is not defined under a JCT form of contract, and it is reliant on the architect's opinion that the works are complete. It should not be conditional, and it is common practice for PC to be granted when the works are substantially complete. However, there may be minor defects or omissions with nothing to prevent the employer from taking a key term, beneficial occupancy. The next question we'll take a look at is, what are the 3 ways that benefits can be transferred under JCT forms of contract? And to address this, we can make reference to, firstly, collateral warranties, third-party rights, and assignment. We'll now take a look at some questions focused on the NEC form of contract. The first question we'll take a look at is a very basic, high-level question, and that is, what does the NEC stand for? Candidates will need to make reference to the new engineering contract. We may also be asked a question on the different disadvantages of the NEC forms of contract, and to address this, we could make reference that they are often only considered to be used for civil engineering projects and partnerships, and they have limited exposure to the market, so they are therefore not fully tried and tested with supporting case law, in comparison to well-established competing forms. We may receive a question on the different roles of the parties under the NEC form of contract, and when answering this question, candidates can discuss firstly that the project manager can be from the employer's organisation or an external consultant, and the project manager represents the client and has full authority to make decisions unless the employer has restricted their authority. The PM has the duty to be impartial and to apply the contract, and designers prepare the works information and are not named under the NEC. The supervisor is either from the employer's organisation or an externally appointed consultant, and the supervisor's role is to check the works are carried out as described in the contract, similar to a clerk of works, and they have authority to instruct searches or issue defect certificates. We may receive a follow-on question asking what the role is of the quantity surveyor under the NEC form, and candidates will need to advise that the role of the QS is not mentioned under the contract. The QS can adopt a supporting role to the contractor and PM to agree costs of compensation events, despite not formally being referenced. Options B and options D involve quantities and measurement, and target cost under options C and D require an audit role in open book accounting in target contracts which the QS may be responsible for. The next question we'll take a look at is how are ambiguities and inconsistencies dealt with under the NEC. Under clause 17, they are awarded in favour of the party who did not provide the works information. The PM issues an instruction to vary the works information, which then forms a compensation event. We may receive a question on our understanding of the term compensation event, and to address this we would need to make reference that these are events which, if they do not arise from the fault of the contractor, they entitle the contractor to be compensated for effect on the price, key dates and completion date. There are 19 compensation events listed in total. We may receive a follow-on question to this asking us to name some of the compensation events, and whilst we won't read through this entire list, we could make reference to changing the works information, access to the site, discovery of an object of value or historical interest, an instruction to search, adverse weather, and an employer's breach of contract. That brings us towards the end of the Q&A practice. I really hope you found this Q&A useful, and please subscribe to the channel to receive ongoing APC support.